In an era where commerce and trade shape our daily lives, it becomes imperative to protect the rights and interests of consumers. Consumer law acts as the guardian that ensures fairness, transparency, and accountability in the marketplace. It's my privilege to introduce to you our esteemed resource person for today's expert lecture on practical perspective of consumer law, Mr. Akshay Baburao Yadav, Teaching Associate, National Law School of India University, Bangalore. He completed his bachelor's and master's in law with a specialization in constitutional and administrative law from Karnataka State Law University. He was appointed as Research Associate at Chair on Consumer Law and Practice and within no time promoted to Teaching Associate at the National Law School of India University, Bangalore. He is a Deputy Editor of the International Journal on Consumer Law and Practice, Scopus Index, and UGC Care Listed Journal since 2020 and March on Consumer Law and Practice, a biannual magazine since 2018. He qualified as an accredited mediator by completing 40 hours of mediation training program at the National Law School of India University. He has presented various research papers at national and international conferences and seminars and has published various works specifically on consumer law, tobacco control laws. He also has some international representations to his credit. He is the next generation leaders of Consumer International, London since 2020. He presented the paper titled Examining Privacy Issues of Consumers Posed by E-Commerce at the Asian Law Institute 18th Annual Conference virtual held on 15 to 17 September 2021. Presented and authored the paper titled Commemorate Second Year Establishment of the Central Consumer Protection Authority in India. Something to learn and adopt at the AGA Africa or University of Pretoria International Consumer Protection Law Conference. An interactive workshop held on 15 to 17 September 2022. Recently participated in International Product Safety Week organized by European Commission in association with the United Nations Conference on Trade and Development held from 14th November 2022 to 17th November 2022 at the Brussels, Belgium, and shared his view as panelist during the panel discussion of EC UNCTAD workshop. Next generation of product safety ambassadors held on 17th November 2022. We warmly welcome you, sir. Thank you. Over to you.
First of all, I would like to thank KLE Institution of Law College Bangalore for inviting me to guest lecture over here. And even I'm proud to be here because I'm the alumni of KLE Institute. So I pursued my graduation like procedures consumer commission. So consumer protection, when we talk about consumer protection, as we all know, it's it is going to touch to each and every human being, right? And protection of consumers is being dealt under various other legislations. Like for food products, we have Food Safety Standards Act. For insurance services, we have insurance laws. For banking services, we have banking laws like RBI Act and various other legislations. Even Drugs and Cosmetics Act for drug products. If you go on listing, there are it's a huge. And when we talk about the consumer protection during the year of 1986, a separate legislation was been brought up for the purpose of providing more protection to the consumers. So the very preamble of the Consumer Protection Act of 1986 states that it is for the better protection of the consumers. There were various lacunas in the act because e-commerce was not been statutorily recognized under the 1986 Act. Product liability chapter was not there. Even there was no authority at all in India to govern unfair trade practices, and that is where the government of India thought of coming up with new legislation repealing the Consumer Protection Act of 1986, and that today we have the Consumer Protection Act of 2019, which came into force on totally on, or all provisions of the Consumer Protection Act 2019 came into force on 24th July 2020. Whatever the consumer authorities or the redressal mechanism which was there earlier in the Act of 1986, with respect, there was three-tier redressal mechanism which was there in 1986 Act. The same was been adopted in 2019 at district level, state level, and national level. But with respect to the changes which has been brought forth for the Consumer Commission is with respect to pecuniary jurisdiction of Consumer Commission, territorial jurisdiction of Consumer Commission, including including they also brought the mechanism of mediation within the ambit of Consumer Commission as an alternative dispute redressal mechanism to resolve consumer disputes. Another authority, Central Consumer Protection Authority, is also been established, wherein a limited power is been demarcated to Central Consumer Protection Authority, wherein it can deal only the cases relating to class actions. So, authority. But for the today's discussion, we will be discussing more with respect to consumer commissions, the filing of complaints, the e-filing mechanism which has been brought by the authority to file a complaint, and some technicalities. We will go more in with respect to the technicality aspects, like how to file a complaint, how to draft the complaint, what are the circumstances wherein while filing a complaint wherein we are required to look into. So we will be concentrating more with respect to technicality aspects, because almost like already you have, like the ma'am has already delivered the lectures on you with respect to the procedural aspects. And so as you all know, there is a three-tile redressal system which has been adopted, and you all are aware of the pecuniary jurisdiction. The pecuniary jurisdiction of district commission, the jurisdiction should not exceed 50 lakh rupees, and for state commission should not jurisdiction exceeding 50 lakhs up to 2 crore, and for national commission about 2 crores. But earlier, when the act was enacted, in the act, the jurisdiction was too higher, and because of huge number of filings that were taking place before the district commission, and the district commission were overburdened, and the ministry thought of, there is a case which was been filed before the Supreme Court stating that huge pendency of the cases are being before the district commission, and all the filings which are been taking place are before the district commission, and there were no cases at all at the state level and the national level. So that was the instance which occurred after the enactment of the 2019 Act. Suddenly, the Ministry of Consumer Affairs constituted a committee to work on this, wherein IIPA, the Indian Institute of Public Administration, submitted a report to the Supreme Court, and that is in case of inaction of the government in appointing president and members, staff of district and state consumer dispute redressal commission, and inadequate infrastructure across India versus Union of India. This is a suo motu case. So here it is. This is a suo motu case wherein Supreme Court is looking after the implementation of Consumer Protection Act. Is looking after the implementation of Consumer Protection Act with respect to infrastructure, with respect to mediation cells, whether it's been established or not, whether the working of the Consumer Commission, even the Central Consumer Protection, all the implementation, like total implementation of Consumer Protection Act is being regulated by the Supreme Court by taking suo motu action, and wherein even with respect to jurisdiction also, the Supreme Court took a suo motu action and required the central government to furnish the details with respect to how many cases have been filed before the district commission, how many vacancies are there, what is the reason behind delay of disposal of cases. So those all are been taken note by the Supreme Court, and Supreme Court directed to revise the jurisdiction, and the revised jurisdiction is before you all. So, but they revised the jurisdiction by means of making rules. By means of making rules. Why is it so? Thus, lawfully, whether making rule, revising the jurisdiction, Is it legal? Is it legal? Because the primary act, under the primary act, the jurisdiction is very different, and through making rule, they revise the jurisdiction of the. But this is actually in actual practice, this should not be happen. But still, they have done this. We have to take it from the point of consumer protection itself again, like because of the circumstances which were prevailing, because COVID was there, and due to which the sessions were not been conducted, and that is the ratio behind like coming up with a rule. But still, it has been approved, and the jurisdiction is been revised. So with respect to qualification of president and members, I won't go much in detail with respect to the president and members of the commission qualification. But whereas here again, in case of Secretary Minister of Consumer Affairs versus Mahindra Bhaskar Limna, this is a case of 2023, decided on 3rd March 2023, recent case, wherein the qualification of president, the qualification of member was being challenged. Specifically, Rule 3 Clause 2B, Rule 4 Clause 2C, and Rule 6 Clause 9 of Consumer Protection qualification for appointment, method of recruitment, procedure for appointment, term of office, resignation, and removal of president and members of State Commission and District Commission Rules 2020. This was being challenged. So basically, Rule 3 Clause 2B. So this is with respect to qualification of member. Rule 3 Clause 2B as well as Rule 4 Clause 2C. So qualification of member wherein 15 years and 10 years is been included, and this was been challenged. So who can be a member? Any expert in the field of like other sectors, sectoral law, right? So that such person who is having experience of 15 years or 10 years, he can be a member. Through it has its own procedure, like he has to give examination and interview procedure is there, and then he will be appointed as a member of Consumer Commission. So this was being challenged before the Supreme Court in this case, and the Supreme Court held that it is violative of Article 14 of the Indian Constitution and unreasonable. It was being held as unreasonable. So what should be the what are the grounds of this? So the term which was being mentioned, that was being held as violative because the term 15 years, what is the background for that? The term 10 years of experience, what is the background for that? So that this is what it was being challenged, and it was being held as violative of Article 14 of the Indian Constitution, and the Supreme Court directed the Ministry of Consumer Affairs to revise this clause. Even coming to the salary allowances and other terms and condition of services and president members of district commission, here also basically this rule was not being implemented at state levels because the central government has through rules made that the members, the salary of members and president of the consumer commission should be according to the they have provided some certain this one, right? Basically the salary has been set according to the secretary level or like that as it has been mentioned, and that was not been implemented at the state level because this is a central government rule and the state governments were not implementing that. So here in sumo only Supreme Court in case of in re pay allowance of members of the UP State Consumer Dispute Redressal Commission, this is a WP of 1144 of 2021, wherein Supreme Court issued a notice to all the state governments to pay the allowances as per the rules which have been drafted by or enacted by the central government. So jurisdiction I already explained with respect to the jurisdiction. This is the case in reference in action of the government in appointing president and members, as I already told you. And this is the rule, consumer protection jurisdiction of district commission, the state commission and the national commission rules 2021. By rule 3, they revised the jurisdiction. So here is an example for you. Mr. A has purchased an insurance policy by paying a premium of 4 lakh rupees for his imported car, some insured of which is 2 crore rupees. During the policy period, the car met with an accident and it was severely damaged. Mr. A raised the claim before the insurance company, but the insurance company did not respond. Mr. A wants to file a complaint, advise the appropriate jurisdiction. So this is just you can analyze the example and if you could answer anyone. So Mr. A has purchased an insurance policy paying a premium amount of rupees 4 lakhs and on mature like if there is any defect in the car or if there is an accident then 2 crore rupees will be the insured amount. So in that case, what will be the jurisdiction of consumer commission if there is any grievance between the consumer company and a consumer? Insurance company and consumer. State commission. Why state commission? Okay, pecuniary jurisdiction. So you are looking at 2 crore rupees, right? But what is the change that has been taken place for the pecuniary jurisdiction? On what basis the pecuniary jurisdiction is calculated? On what basis the pecuniary jurisdiction is calculated? Pecuniary jurisdiction is calculated on the basis of consideration amount paid, right? On the basis of consideration amount paid. So what is the consideration amount over here? 4 lakh rupees, right? So this is the consideration amount. So on the basis of this, the case will file before district commission. So even say for example, in life insurance policy, you have to pay yearly premium, right? So you are paying. So you bought a life insurance policy, and you have to pay amount of rupees 1,000 for 15 years. Amount of rupees 1,000 for 15 years, and the maturity will be after 20 years, and you will be getting 20 lakh rupees. Okay, 20 lakh rupees, and you have paid for 6 years. You have paid for 6 years. 6,000 rupees you have paid. Okay. Whether the consideration amount. So that is why the clause is very clear. Consideration amount paid. So you have to calculate the jurisdiction only on the basis of 6,000 rupees. Not for whole 15 years which you have promised. Only for 6 years which you have paid. On that basis you have to calculate the pecuniary jurisdiction. Okay, whatever the compensation it may be above 50 lakh rupees. It may be 2 crore, it may be 3 crores, whatever it may be, but pecuniary jurisdiction should be calculated on the basis of consideration amount which is paid or not. So the same is been held in the case of Pyari Devi Shabiraj Steel Private Limited versus National Insurance Company Limited. This is the case of 2020, where it held that the pecuniary jurisdiction should be determined based on the consideration alone, has to be taken, and not the value of goods or services provided. Even if you want to buy a car and for an initial purchase, you enter into an agreement with the opposite party paying 50% of the amount of the car. 50% of the amount of the car. So the consideration amount should be considered on the basis of the paid value and not on the total value of the goods. This is what it has been held in this case. So here is another example. A, B, C and D are the opposite party against the consumer. Mr. X in a consumer complaint. A and B are residing in Bangalore. C and D are residing in Dharwad. To institute a complaint in Bangalore, the permission of the Bangalore Consumer District Commission must be obtained. Similarly, if Mr. X consumer chooses to file a complaint in District Commission of Dharwad, he has to obtain permission from the Dharwad Consumer District Commission. So basically, when a complaint exists in two different jurisdictions. Similarly, in this case, wherein A and B are residing in Bangalore, C and D are residing in Dharwad. So under that circumstances, so basically this scenario will exist in there are two different circumstances. If a consumer wants to file a complaint, because here there is only one consumer, here there is only one consumer. With under the new act, the territorial jurisdiction has also been revised, wherein they came up with the thing that the territorial jurisdiction of the district commission will lie before where the consumer resides. Under that circumstances, there is no point of this scenario. Like permission, there is no requirement of any permission at all. But if a consumer wants to file a complaint where the opposite party resides, because there is other clause as well, right? And under that circumstances, there are 3 to 4 opposite parties and residing in different jurisdictions. So under that circumstances, the consumer needs to seek the permission of such district commission and file a complaint. So
So in any one place you can find the complaint.
in any place he can file, but where the opposite party is residing in, not consumer. If he wants to file where the consumer himself resides, there is no requirement of any permission at all. If he wants to file a complaint where the opposite party is residing, then there is must to obtain a permission. Cause of action, coming to the next aspect of filing of a complaint, cause of action. So the importance of cause of action is to determine right to sue. Unless and until you have a right to sue, you can't file a complaint before any courts, right? And so cause of action. When does the cause of action arises? So there are various circumstances you got a product, and that is defective. Whether at the instance when you determine that the product is defective, from there the cause of action arises at the first instance. At the first instance, if in case you didn't file a complaint, because this cause of action is very important to determine the limitation period as well. Limitation period for filing of a complaint. So, at the first instance, cause of action arises when you get to know that the product is defective. But you try to approach you don't want to file a complaint and create hazards between you and the company. And that is why you approach the company. You approach a company to settle out the matter that this product is defective and kindly replace or refund me the amount for that product. The company denies it. At the instance where the company denies, from that period the cause of action or the limitation period will start. Say for example, the company doesn't deny and it will promise you that I will pay on so and so date. Then also he doesn't pay. So the date which has been mentioned, from that date the cause of action will start. So this is, we call it as continuous cause of action. In certain circumstances, say for example, delivery of possession. You purchase a constructed house, or you ordered a builder to construct a house for you, and the builder said that I will deliver you the constructed house on so and so date, but he doesn't hand over the possession. Although you have paid all the consideration amount which you wanted to pay, everything is done, but the possession is not being delivered by the builder. Unless and until he delivers the possession, the cause of action continues. So there are various case laws which helps that in case of delivery of possession, that the cause of action will be continuous. But the builder has denied that I will not provide you the delivery, or I will not deliver the position to you at all. He denies, he totally denies on some date. From that period, 2 years limitation will start. Okay. So coming to the next aspect, next important aspect, like that is court fees, which is required to pay for every complaint. And so earlier, there were various talks which were going on with respect to court fees as well, and when the act was being enacted, so during that time the pecuniary jurisdiction was very different of all the district commission, state commission, and national commission, and based on the revision of jurisdiction of the commissions, the National Consumer Dispute Redressal Commission came up with a revised court fee, which increased whatever the court fee which was included in the rule. So that was there, but the National Commission through order totally increased the court fee of the Consumer Commission for filing of a complaint. And there was a confusion with respect to which rule we have to follow, whether the rule which has been enacted by the central government or by the National Commission. So that was the confusion which was there, and recently the Ministry of Consumer Affairs came up with revised court fee through Consumer Protection Consumer Dispute Redressal Commission Amendment Rules 2022, and the revised court fees as here. They didn't revise, they didn't increase, they didn't decrease the court fee amount which was there earlier, but whereas they only shifted the terminology, because as per the pecuniary jurisdiction which is revised, 50 lakhs was for district commission, and accordingly they revised the earlier the state commission was here, and they just shuffled the. So here is another example for you to identify the court fee required to pay. I hope you all have the bare acts, right? You can just have a look at it. The same example which I dealt with earlier, the premium case. Now here the jurisdiction is before district commission. Consideration amount paid is 4 lakh rupees. What would be the court fee? No court fee. So once now everything is ready, I will in the next slide I will just show you the drafting of complaint, how it is required to be made. But beforehand I am just taking you through the provisions, like what are the essential requirements for drafting of a complaint. So I am dealing with that, and in the next aspect we will deal with the complaint filing or drafting of complaint. So basically coming to the section 36, like proceeding before the district commission. So every complaint has to file before the district commission by consumer, or it is already been defined like who is the complainant under the act. Like consumer himself can file a complaint, either state commission or central government or state government can file a complaint, even CCPA can file a complaint, right? One or more consumers can file a complaint. The complaint will be filed before the district commission. What should the district commission should do? The district commission, once the complaint is being placed before the district commission, the district commission will scrutinize the complaint, and then admit the complaint by order within 21 days. So once you file a complaint with the district commission has to admit the complaint within 21 days. If there are any discrepancy in the complaint, so 15 days time will be provided to the consumer to rectify that. And within that period, he has to submit the rectified complaint copy to the Sirasdar, and again there will be scrutiny. If he didn't submit the rectified one, under that circumstances, the Consumer Commission should hear the matter on the merits of the complaint which is already been there, and then decide the matter accordingly. another important aspect for redressal of consumer dispute, that is mediation, was brought into picture, and wherein section 37 empowers the consumer commission to refer the matters which can be settled through mediation. So there is a list of matters that can be settled through mediation under the consumer protection mediation rules that is been provided, and they have also included which all are the matters that cannot be settled through mediation. And if the president or members deems that that matter can be settled through mediation, it can again refer to mediation cell established attached to the consumer commission. So chapter 5 of the Consumer Protection Act, along with the Consumer Protection Mediation Rules and Consumer Protection Mediation Regulations of 2020, deal with mediation, wherein appointment of MPanel, appointment of mediators, qualification of mediators, and with respect to rules, ethics of mediation, those all are been described in broad, and the principles of mediation are also been well recognized under the Act. So once the complaint has been admitted, what is the procedure? So the procedure is described under section 38. So there are two types of procedure. One is with respect to goods and another is with respect to services. So for goods, once the matter has been admitted, then the copy will be sent to the opposite party. The opposite party comes with a written statement or written version, that what we call in consumer commission. Once the opposite party files a written response, then if there is any testing is required for the goods, then it will be sent to the laboratory. The laboratory will test the product. It will again send a report to the commission. The report will be, and like the copy of a report will be given to the opposite party, and then the opposite party, if the opposite party wants to file a rejoinder or uh, reply to the report, then it can provide a reply to that report, and on the basis of that, the matter will be heard and decided by the consumer commission. Even with respect to the service, if there is no requirement of any report or for goods are not required, then directly it will be then directly on the merits of the case, the commission will hear the matter and then decide on the merits of the case. With respect to services, so services will be the same pattern will be there, and so based on the evidences put forth by the parties and on the merits of the case, the consumer commission will decide. So there is a time limit as well for deciding the matters. So it is already been discussed by ma'am, and I think we are briefing, so I have to repeat. So that is 45 days. So basically, again here the main importance is like once the opposite party receives a notice, within 30 days he has to file a written response. The opposite party has to file a written response within 30 days. Within 30 days he has to file a written response. But the court also, the consumer commission has also discretionary power to extend that for further extension of 15 days and not more than that. So in total 45 days will be granted to file a written response. So that has already been held in various cases. The recent case law is New India Assurance Company Limited versus Delhi Multipurpose Cold Storage, wherein it held that beyond the 45 days it should not be. In this case it accepted, but in the letter version it said that it should not provide. So coming to the format of drafting of complaint. So basically, whenever we are drafting a complaint, so we have to look at the basic principles, and that basic principles are nothing but the cause of action, the jurisdiction of the consumer commission, the court fees required to pay, and before under which provision you want to file a complaint. So these are the basic things which you are required to look into. So based on the jurisdiction, you will decide the court or commission before which you want to file a complaint. It may be before national commission, state commission, or district commission. Based on the territorial jurisdiction, you will decide the state commission before which you want to file a complaint, or the city before which you want to file. So based on territorial jurisdiction, and based on peculiar jurisdiction, either it may be state commission, national commission, or district commission. So here the complaint number. The complaint number you need not require to write when you are putting the complaint before the. So this complaint number will be inserted by the Sirastadar or the Consumer Commission or the officer. So usually we call it them as Sirastadar, or we can also call it as a commission or like Consumer Commission officer as well. So he will insert the number based on the registry and based on the register number. So once you file a complaint and once the complaint is admitted, so once the complaint is admitted, he will insert into a register. So the register will maintain the registry, and in that, at which number the register will be there. So that number will be inserted over here. So the one who is filing a complaint, we call them as complainant, and so here we have to provide the name of the complainant with full address, full name, age, gender, address of the complainant, email, mobile number. Now in the present this scenario, email and mobile number are mandatory. Given I have missed out over here that occupation is also required to be inserted over here. Occupation. Why occupation? Why occupation plays an important role in filing of like why we should insert over here? Anyone has any idea? Why occupation is important? Would be important for drafting of complaint or filing of complaint.
Because of income. Income.
Income.
Decide whether the person was higher or lower.
How occupation will determine that?
He was a manager.
Because any person can. The occupation will determine a very important aspect of consumer protection, that is commercial purpose. Because commercial purpose, if there is any commercial purpose involved in the matter cannot be dealt under Consumer Protection Act, right? Am I right? Because the very definition of consumer exclude commercial purpose. And in order to determine whether the matter is a commercial purpose or not, the occupation plays a very vital role given the facts and circumstances. Because this occupation may be very different from the product which you have brought, right? So in order to determine that, this occupation will play a very vital role. So the important aspect while inserting the name of the parties or the name of the complainant is you should include all the necessary parties. You should include all the necessary parties. You have purchased a product, and because of there is a defect in the product, and because of that product, while you are working with that product, there's someone sitting beside you. It may be your child, it may be your friend. Because of that product, he got damaged or injured. He gets an injury because of that defective product. Whether he will get a compensation?
Yes.
He will also get a compensation, right? So, all the necessary parties is required to be included in complainant, even under opposite party. So here, full name, age, address of the opposite party is also required to be given. and it is the onus on the complainant to get the addresses and the details of the opposite party as well. Now complaint under section. Which section you want to file a complaint? So it depends on the jurisdiction on which that section you have to include the jurisdiction which you determine. It may be of district commission, state commission or national commission. Accordingly, you are required to insert the section. And then this is just a brief idea with respect to the introductory aspect. You have to give the brief idea with respect to, in case of serving of notice, to whom you should serve the notice, either to the consumer himself or to the, if any agent is appointed or if there is any advocate is appointed for you, then on whom the notice is required to be served. So that you provide in an introductory para for the purpose of serving of notices or for the purpose of serving of summons or any other information that the consumer commission needs to furnish to the consumer. Then you should furnish before the who you choose, who a consumer or a complainant wants to choose. It may be himself or it may be his advocate. If he wants to serve a notice for an advocate, then he is required to give the advocate address as well over here. If you want to serve for himself, then he can just mention that whatever that has been mentioned in the cost title. So the earlier we called it as cost title. And this is the body of the complaint. So in introductory para, so this is what we will include, and along with that, the opposite party address. So here, for the opposite party, you may not require to, because you are not going to determine who will be the opposite, like I don't know whether the opposite party is going to give authority to the advocate or not. You don't determine that. You can just mention the addresses that has been given in the cost item. So that is required to mention. Then you have to briefly describe about the course of like transaction that you have been taken place. If you are like, if you have purchased the product, so when you purchase the product, the purpose of the product which you purchase, the purpose is very important, is because to determine the commercial purpose, whether what was the purpose behind that, so that you have to describe. Thereafter, what is the defect in that product, you have to describe. Then, if you have, before describing the defect in the product, you will be mentioning with respect to when you purchase that product, how you purchase the product, the purpose of purchasing the product, and if there are any receipts. So you will be disclosing the receipt numbers and whatever the details that are there in the receipt. So those all things you are also required to describe in the transaction. The first para of the body of the complaint will be your transaction details, whatever it may be. And even if you have purchased that product for your child, or if you have gifted that product to some other person, so that is also required to be included, because in the very definition of consumer, it has been dealt like if you have gifted that product to someone else, that is also been covered within the ambit of consumer protection, because you have purchased that product for the benefit of other. So this is all about transaction. And then nature of complaint. In nature of complaint, you will be describing the defect or deficiency in service or whatever the unfair trade practice that has been carried out by the company. So you will be discussing the nature of complaint. So here it may be relating to misleading advertisement or false advertisement, cheating by giving false promises, deficiency in after-sales services or not abiding by the warranty clause, harassment by the opposite party, non-delivery of goods or services, charging excess amount, any other factors that affected the consumer. So it may be on any grounds. So the grounds are being clearly defined under section 38 as well. The manner in which the complaint shall be made, the grounds are already been defined. And based on that, so you can file a complaint. So, is certified. Manner in which complaints shall be made. So in that clause, there is the list of cases that can be filed. Once you furnish the nature of complaint, then what are the rectification you sought? So how you approach? Like rectification means have you approached the opposite party or the opposite party to initially try to settle out the matter? Like say for example, if the product you have bought from an Amazon, if a product you have bought from Amazon and that is defective, so what is the first instance which you have? You have to try to return the product, right? But Amazon didn't accept it. Then what is the second option you have? The second option you have is to call the customer care. Then also they didn't reply. Then third option, send a legal notice, right? Send a legal notice. You sent a legal notice. You got a reply that they denied to give the or refund, whatever it may be. Basically, it is based on nature of complaint. So they deny. Once they deny, so that is what the limitation period. This is where the cause of action will arise to file a complaint. This is where the cause of action will arise, and that you are required to. So whatever the transaction that has been taken place between you and opposite party to establish the cause of action. To establish the cause of action, you will be describing it in rectification. So you will be describing in rectification. Then once you describe that, then there will be a provision for cause of action, like how the cause of action arise. So what was the reason behind establishing the cause of action? So it may be continuous cause of action or it may be other way. So and then once you mention the cause of action, so you can mention or it is not mandatory to mention the provisions. Like it's not mandatory to mention the provisions under the or while filing the complaint. So there is no requirement at all while filing a complaint. But under circumstances you may require like this is misleading advertisement. So you may provide with details of that provisions as well. Along with that, you will support them with evidences. Usually what a good lawyer will do or a good drafter will do whenever at that instance, say for example you are explaining the transaction. So what I earlier told you that you have to attach the receipt. So you can just annex over there itself, right? This has been attached. The receipt of the sale has been attached as annexure 1. While dealing with the nature of complaints, the defective product. If there is a defective product, you can take the snaps of that defective product and include. And you can also mention in that the snap of the product or the picture of the product is being included as an action 2. Or you can also produce that defective product itself. So you can just include there itself, there itself, so that it can be very easily for a consumer commission to understand. Then territorial jurisdiction, how the territorial jurisdiction, you have to again just describe about the territorial jurisdiction, how this court has a territorial jurisdiction to entertain this matter, even pecuniary jurisdiction, and then you have to mention the limitation period, the court fee, and then prayer. So this is the format of filing of when you are drafting the prayer, it is very important to know that. So what actually you are going to claim, and whatever the claim you want, that has to be mentioned in the prayer. If you say that whatever the court deems fit, it also suffice. But under circumstances, under certain circumstances, the court also may not also determine what actual the consumer needs or what actual the compensation that is required. So there you have to clearly describe the prayer, and then very importantly the verification clause. So whenever a consumer files a complaint, so under that circumstances, yeah, the verification clause doesn't play a very important role. But when an agent or when an advocate file a complaint, Then the verification process plays a very vital role that whatever that has been described above are known to me and according to so these whenever you file a complaint, you should be well aware of the complaint what you have drafted and the knowledge about that complaint. So that is where the verification process plays a very vital role. And even so it is mandatory for all the persons. So verification clause is must in all the complaints. So with this is all about drafting of complaint. With respect to the arrangement of the complaint, so at the first instance you have to draft an index. So index should consist uh, usually you also draft index for your projects and all those things. So similar type of index will be there. So which will be describing like at what page number the complaint is available, at what page number the memo of the parties is available. I will describe you on what about memo of the parties and all those things. So firstly there will be an index page, then the memo of the parties, then the complaint, then the evidences. So this is the list of index that is being covered. So memo of the parties is nothing but the, the draft which describes the parties. This is what the memo of the party means. So usually whatever we have included in the first item, which I discussed earlier with respect to the details of complainants, the details of opposite party, that we call it as memo of the parties. So every complaint has to be, if there is any like uh, even affidavit is also mandatory for filing of a complaint, but basically that is not required as per the law, but in usual practice, the most of the consumer commission requires to have an affidavit on the complaint for the complaints as well. It is not mandatory, but in actual practice, they are doing this. And even the format which I have shown, this is not a mandatory format. This is neither like because the consumer commission is very consumer friendly, and that is where the act neither the rules doesn't define the format of the complaint. So it can be on a plain paper because the rules mention that it should be on a plain paper and the transaction details suffice the thing. But the thing is like in actual practice that is not in so they require in this format most of the times. But again, this format is being mentioned for earlier under 1986. The format was been uploaded on NCDRC website, and this is the format which we have revised according to this new legislation. So this is all about drafting of complaint. If you have any confusions, I will be happy to take up. I have another 10 minutes of time, so I will be dealing with the filing of complaint. So before I move on to that, if you have any,
So some shop is charged as a cooling charge for tax and dairy products or for soft drinks. Some shopkeepers charge as a cooling charge for some dairy products or for some soft drinks.
okay,
Like, is it valid to charge like
it is illegal. See, basically on cooling, like say for example, Pepsi cans or milk products, whatever it may be, the shopkeepers who charge cooling charges is totally illegal, and such charges are being applied on the products, then you can file a complaint before Consumer Commission.
what
Because
compensation is given for that?
so compensation it depends on facts and circumstances of the case, because usually what Consumer Commission has given the compensation is up to 5,000 rupees or so like that. So basically, why the very so for the price we have to know the MRP. So that is the maximum retail price, which includes the cooling price as well. So that's well decided in various cases. Even the judiciary has played a very vital role, wherein you might have also witnessed that the prices at malls and restaurants are very high with respect to Pepsi cans and all those things. For the wherein when we compare such Pepsi cans with the outside outlets, so for the same quantity, the price charged at malls and multiplex are very high, and that is already been decided as illegal by Karnataka State Consumer Dispute Redressal Commission. And that case was also been filed by the students of MLSL. Yeah, any other questions?
Sir, restaurant charge service charges. Is it legal or illegal?
Student,
Service charges.
hotel service charges.
Yeah.
So basically, hotels which are charging service charges are presently, right at this moment, the Central Consumer Protection Authority came up with the guidelines like that hotels and restaurants should not charge service charges. But the same is being stayed by the Delhi High Court, and it is yet to decide. Like, but as per the standards, as per the standards or as per the other laws, like you can take up with income taxation laws and all those things. When you study all these laws, what I personally feel, because as per my research or understanding, like the hotel and restaurant by imposing service charges on the part of consumer, they are escaping from the tax for that and they are like reserving. Earlier, during the period of 1980, 1986, why the service charges was being collected. So the service charges, usually what we used to do is like we used to provide a tip to a person who is delivering the product to you at hotels and restaurants. But for what purpose you were providing the tip? What was the intention? Because you like the food product and not the services which was being provided by the service provider, right? You are providing the tip for food. And the hotel association came up with a regulation that, right, because of this, because the cook who prepares the food, he is not getting anything, and the service provider is getting tip for that. And that is where no one is ready to take service like employ as a cook and he wants to employ as a service provider. That was the circumstances which was been arising. And that is where the service providing tip that in the form of providing service charges was been established at hotels and restaurants. That was the intention. But at this present day, what this hotel and restaurant started doing is like they started collecting the service charges, but they were not giving it to either of the employees, either to the service provider, neither to the cook. So that was the circumstances which was arising, and to tackle up with this, the central government came up with the right. Hope you understood this. Yes. Now we don't know where the how the High Court is going to decide, but it depends on that. So let's move on to the next aspect, that is filing of for filing of complaint, for e-filing of complaint under the Consumer Protection Act, that is well recognized under Section 17, Section 35, Section 38, Section 65, Section 101 and 101 Clause 2. Am I required to do the provisions? So, the commencement of electronic filing that was being taken place by establishment of e-Dakhil portal by National Consumer Dispute Redressal Commission and Honorable President of NCDRC released this on 7th September 2020 through a notification. And this is the portal link, that is https://edakhil.in. So for filing of a complaint or written response or rejoinder, whatever it may be, so the consumer or the advocate, he has to register with the portal. So for registration, he is required to have an email ID, the soft copy of the identity proof. It may be voter card, it may be license, it may be ration card, whatever it may be, but it should be a nationally recognized card, ID card. So that you are required. You have to require to go to the e-vacuum portal. Therein you are required to click on registration, and then by inserting the user account information, personal information with respect to name, father name, date of birth, address, and ID proof. You have to upload the ID proof for the sanctity purpose, and then you have to identify yourself as a human being by inserting the captcha, whatever that has been provided. By inserting the captcha, you have to just identify yourself as a human being, and then you have to register. So once you register on your email, as well as you can also insert your mobile number, wherein you will get an OTP for authentication of email ID or the mobile number, and then you have to insert the mobile number. Once you verify the OTP, then you will be registered. Once you register, then you will be able to file new complaint. You may file first appeal, revision petition, written response by the opposite party, rejoinder, payment can also be done through this portal. So what is the mechanism for filing of a new complaint? So for filing of a new complaint, first of all, with the registered ID, email ID which you have registered, so you have to log in. Once you log in, so there are various tabs which are available. So here, filing of a new complaint. So you have to click on filing of a new complaint. You will get a disclaimer. You will get a disclaimer that So you will get a disclaimer as to like whatever the information which you are going to furnish are true and best to the knowledge, as we include as a verification clause in each and every document. Even with respect to privacy, with respect to confidentiality, that all things have been discussed in this disclaimer form. Like you are going to agree, and even how the privacy policy of this portal is available in the disclaimer. So that you have to read and you have to accept that policy. Once you accept that policy, you will be taken to the tab called consumer case. So CC. Usually we call it as, whenever you file a complaint, you call it as CC, or filing of a first appeal, we call it as FA, and so on and so forth. So yeah, whatever it is there, like it is available in rules and regulations. Once you click on CC, then it will take you to the tab called where you are required to include the claim amount of actually pecuniary value. Pecuniary value is nothing but the consideration amount paid. So you have to include that, and based on that, you have to select the state and the city where the cause of action was arise, and then you are required to click on continue. So once you click on to continue, then you will get that form wherein you are required to give the details of a complainant, like whatever we discussed earlier, na, the occupation, age, name, those all information you are required to give it over here, including the details of the opposite party. So you are required to give the details of complainant, you are required to give the details of opposite party. If there are any additional complainant you want to add, then you can add over here. Going to the next tab, add additional complainant. Even you can add additional opposite parties. So for the purpose of complainant, I have described who all are the complainant, like additional parties to the complainant. Whereas with respect to the opposite party, who all are the opposite parties? Who all are the opposite parties? Manufacturer, yes. Seller. Shopkeeper, I mean, we can call it as a seller. Manufacturer, seller, any other?
Middleman.
Sorry?
Middleman.
Middleman. Okay? Agents. Under circumstances, we cannot bring them within the country of this, but yeah, okay. Yes? Any other? Service provider? right? So these all are the opposite party wherein you
So
can
brand ambassadors.
brand ambassadors. Perfectly right. So we can call them as endorsers. Endorsers. Say for example, misleading advertisement. There is any misleading advertisement and the endorser is good. Here, this is how we fill the forms for additional component. Same information what we provide to the complainant, the same information we have to provide for additional complainant as well as to the opposite parties. Additional opposite parties form. So here, so this is where the actual complaint filing comes. Where you upload the documents. So as I already told, you have to upload the index. So where in index, you will be provided just a one page wherein what all the attachments which you have made to the complainant, you have to include that with page numbers, that index, and where of the list of dates and events. So at what date, what the event was then occurred. So that you have to describe, and so you can upload that document as well. So you have to draft it on a page and you have to upload that. So list of dates and events, like on what date what was happened, like the transaction, when you purchase the product, what was the when does the defect occurred, when does how does you sort the rectification, and when you first approach, what did the opposite party did, whether he sent the notice, on which date he sent the notice. So all details, like by including dates, you have to arrange. Like on the one side, you may require to draft a table. On one side, you can include dates, and one side, what are the transaction that has been happened, and or the events that has been happened. So the memo of the parties, like it should be a page wherein the parties details, all the parties already whatever you have been given, but again you have to include it on a place and then upload. So I have to just cross verify it once again, then again complaint copy will upload. So how to upload that? You can just choose on the files, just click on the choose. You can choose it from the one which you have saved in your laptop or you just upload it. So any other further, it also provides for uploading of additional documents. You can also upload additional documents as to the evidences which you have, like snapshots or any document which provides the warranty details or something like that. So you can upload that as well. So once you upload all these documents and click on next button, then you will taken to the finalization or submission of the complaint, wherein you will be again just checklist. So whatever the documents, whatever the details which you have furnished, once again you have to checklist like whether you have given the details of the complainant and address details, opposite party details, whether you have given the additional complaints if there are any opposite party, additional complaints if there are any. So all these, so you have to just checklist, you upload for that and just submit it. Once you submit, then you will get a OTP verification. By including OTP verification, you will be taken out. Once it's done, once the OTP verification is done, then the complaint will be agreed. So this is the process of filing of a new complaint. Even the same procedure follows while filing the uh, uh, filing of a first appeal or something like that. So just so while filing a first appeal, so first appeal, because this has already been heard and decided by the Consumer Commission itself, so whatever the key details which are there, which were being held by the Consumer Commission, will be uploaded by, it may be like, of whether it may be either by filing of a e-complaint or either physically at the district commission. For filing of a first appeal, there has to be a judgment of a district commission or either state commission, right? So, so you may question that, sir, while filing a complaint before district commission, the complaint has been handled physically. Whether such complaint can also be filed at a state commission while filing a first appeal on an electronic mode. Yes, it can be done. Under certain circumstances, what happens is like the court itself upload the details on the website. Sometimes it may have not uploaded. Under that once it has not, so you have to just verify that. To verify that, you have to provide the case details, free case details. So for free details, you have to just click on the number of the case wherein the district commission has already decided. So that if you insert that number, then it will provide you the free details, whatever uploaded on that portal. If it is not been uploaded, then you can upload it manually as well. So you have to give the judgment order of the district commission also you are required to upload, and then if you want to add more complaint, additional complaints, you can add. Then you go on to upload documents. So while uploading documents, again same procedure: index, event, and dates. Events with dates, name of the parties, order of the consumer commission, first appeal. So first appeal, that you have to upload, and then click on finalize and submit. Again OTP verification, same procedure. While filing of a revision petition, similarly with respect to revision petition also, when we usually file a revision petition? Under what circumstances we file a revision petition?
After the first appeal.
After the first appeal, we file a revision petition. So revision petition can be filed after the first appeal, and same procedure. Whatever first appeal decision will be there, so that order number you have to include, all the free details will be available, not available manually fill, and then proceed to upload the documents. So filing of response, even while filing of a response, sometimes the complainant, like even here also, uploaded documents are there, like free details are available, then again it will take 4. If not available, then the opposite party wants to file a return version, then he can also manually submit the return version on the basis of just including the details of the complainant, the details of the opposite party, because the opposite, once the complainant files a complaint, then a notice will be served or the summons will be served to the opposite party to appear before the court, and it will be having all the details like the number and all those things. Only just inserting all those details, you can file a written response as well. So rejoinder, once the opposite party files his written response, and in addition to the complainant which has been drafted by the complainant, we can also upload the rejoinder as well. So denying the facts what the what the opposite party that has been included. So denying such opposite parties say, the complainant can file a rejoinder for. So payment gateway, even the payment can be done in 2 ways, either online payment or by offline payment. So offline payment means like, so the challan will be, you can print the challan from here, you can pay in the bank, or you can also draft a DD, you can upload that here. So this is the, but in case of DD you have to post that DD, but whereas in case of challan, you can just upload the challan. This is what the offline payment means. And whereas online payment through GPI or any payment mode through credit cards, debit cards, you can do that.
This is application fee.
Yeah.
This one is application fee.
Not application fee, this is court fee. There is no application fee at all. So this is court fee. is the payment gateway. Online modes, debit card, credit card, internet banking, IMPS, Aadhaar, whatever maybe with respect to offline bank, maybe Indian Post Payments, others, there are, yeah, and these are the offline payments. So, with respect to the challenges, like we have a lot of challenges, like infrastructural challenges which we have because state government when we look after the status of the district commission, there are a lot of vacancies, there are a lot of infrastructural challenges are available, and to develop e-docket portal is very mandatory to have lot of computers and internet facilities and all those things. So it's very difficult. Even when we talk about infrastructure, digital literacy is also required. It's another important challenge. Even awareness about this because in the present era, because of the COVID-19, everyone is aware of the facts. Like we should be thankful for the COVID period wherein all the general public are aware of the ODR mechanism that are available. With this, I thank you all for your questions hearing, and if you have any questions, I will be happy to answer.
Uh, if we don't know the opposition parties at this and all
Gender
these
and
things,
all.
what can
So basically, if you are not aware of about the gender and all those things, so you can use it blank. So there is no mandatory requirement that you should provide that. But it's good that you should provide. So again, it depends like under circumstances, you will be well aware of that because you are the one who is dealing with the opposite party. You should be aware of that.
on the behalf of the Academy of College, I express my heartfelt gratitude to our esteemed guest, Mr. AKSHAY. It has been an enlightening and enriching experience having the privilege of attending this lecture. I would like to express my gratitude to our principal, Sir J. and Malika Jr. in his absence here. I would like to extend my gratitude to Vice President Dr. Anita Anjana, RQAC Coordinator Dr. Manoj Kumar Purima, and all the other associated professors in the absence here. Last but not the least, I thank the audience for being patient. Thank you.
You can mute your respective classes. Thank you. Economics, all